Hey folks, it's Rob Flux here with another Sunday session, and today we're talking all about building insolvencies and how you can actually manage your way through that. Now, given all of the issues and challenges that are happening in and around the building and construction industry at the moment, getting a ton of questions with regards to that. And so in order to help me navigate this, I have Julian Troy, I should say, from Troy Legal. Sorry, mate. I'm sure having two first names doesn't help anyone, does it?
It doesn't.
No. So Julian Troy from Troy Legal, you're a building and construction lawyer, which is different to your normal everyday lawyer. Tell us a little bit about Troy Legal and about yourself and where your specialties are, why we should be listening to you today, mate.
Yeah, we're a specialist construction firm based in Brisbane. So we only do building construction law. We don't do other types of law. The bulk of what we do is all about building contracts, interpreting those contracts and reviewing those contracts, managing disputes and litigation in respect to those contracts, and helping parties either defend payment claims or recover payment under those contracts. And we represent parties anywhere in the contractual chain: developers, builders, suppliers, subcontractors, anyone in the contractual chain use our services.
Very good. So now yourself, you're actually based in Southeast Queensland. And so a lot of the things that you're going to be talking about might have a flavour of that, but we're going to try and draw that out to say, how does that apply across the country wherever humanly possible? But note, folks, that there might be one or two idiosyncrasies that are Queensland only, but we'll do our best to navigate that through as we go. So, mate, let's set the scene. Why we're here today, there's a hell of a lot of noise that's happening I guess with regards to builders going broke, and a lot of them, which is over and above normally. Typically the stats are 1 in 5 builders go broke. But that's, I guess, given the circumstances of late, that number has gone up, and there's a lot of high profile ones. Give us some insights into what you're seeing.
Yeah, it's been ongoing now for quite some time. It's been more than 12 months where there's been somewhat of a crisis in the industry. And you've seen big commercial developers like Condev here in Queensland go under, and you've seen big domestic home builders that operate nationally like Porter Davis have the same fate. So it's widespread, and it happens at all tiers of the construction industry. And what's brought it about, I think, is primarily the supply chain disruption, supply chain delays, shortage of product, which has meant cost increases, and shortage of labour, which has meant increased labour costs. And all of those things combined with fixed price contracts, which are common practice throughout the industry, cause a problem because those fixed prices are no longer viable. Yeah,
and I guess a lot of this has come whilst we're well and truly past COVID from a human perspective. This is still the repercussions of some of that playing out, where supply chains are all around the globe were shut down, and that caused the knock-on effect, I guess. And we went into a little mini recession of sorts, and then the government tried to, I guess, reinvigorate us with building bonuses. So every builder on earth, I guess, got a whole bunch of activity, but they're calling this the building boom, where nobody's actually making money.
Yeah, that's right. And it's particularly impacted the residential building sector because of that policy decision to encourage first home buyers and new homes. And unfortunately, you couldn't foresee what the result of the COVID supply chain impact was going to be. And there's other issues at play too, in terms of international wars, and Russia and Ukraine plays a role in terms of pricing of fuel and the rest. But yeah, that's why we've ended up where we are.
Yeah, absolutely. So that's painting a scene, and we're going to talk about what to do, I guess, if a builder actually goes into insolvency, which is where your specialty is. But before we get there, what can we do to try and avoid some of this in the first place, to set ourselves up correctly from a contracts perspective, and from a have we chosen the right builder perspective? What can we do to, I guess, set ourselves up for success? And then later on, we can then talk about what happens if that doesn't quite go to plan.
Yeah, that sounds good, Rob. So you want to deal with the first steps in terms of...
first steps, why don't we talk about due diligence? What should we be doing to try and, I guess, make sure that we've got the right builder in the first place?
Yeah, so I guess the initial step is to do a bit of home research on the builder that you're thinking of selecting. Have a look at, what their history is in terms of projects, what information's available on their website, any information you can find out about their financials. Here in Queensland, there's a thorough search you can do that's all free of charge online in terms of their license and their license details and their history and whatever black marks they may have against their name, and all of these things are recorded and accessible. That's the type of due diligence you'd undertake.
Yeah, and all of those services are available pretty much in every state. It's a different jurisdiction that looks after it in each location. So Queensland, it's the QBCC. Victoria, it's the VBA. New South Wales, I believe it's the Office of Fair Trading. So I guess know who your licensed, your regulatory authority is for the building segment. Look up your builder's license there. And as you said, you can search on the history of projects they've done. You can see the black marks against their name. And in most instances, those building authorities are already doing, regular checks for the financials of the builder anyway. But we want to do something a little bit over and above that where possible, and, get the builder where possible to maybe provide their financials, or at least a letter from their accountant to say that they're actually financially stable.
All of those things are a good idea. And then I guess once you've formed a view that they're someone who's trusted, you then turn your mind to the contractual provisions.
Yeah, absolutely. And then there's what are some of the special conditions and things that we can actually put into the contracts to try and set us up, and probably worthwhile stating there's different kinds of contracts. So there's domestic like construction contracts, and there's more commercial contracts. So maybe we start with, what's the difference between the two, and when does one transition from a domestic contract into a commercial one?
Okay, so most of the domestic building contracts that you see published by the Housing Industry Association or the Master Builders, or here in Queensland it's QBCC, it might be the Department of Fair Trading in New South Wales. They're standard form contracts for domestic building work that encapture what are the standard provisions and requirements that are enshrined in legislation in the states, and they're very much from a consumer focus. So very much about how you adjust the price and what circumstances you can adjust the price of the contract, and the terms around payment and those basic things around when payments payable, and the duration of the contract is important, and what might be penalties in place if those contracts run over time. Those basic parameters are usually in the domestic building contracts. When you start looking at multiple dwellings where there's two or more living units or two or more residences, you're starting to step outside the definitions of the domestic building contract world, or residential building contract world, and stepping into more of a commercial contracting arrangement. Now, the commercial contracting arrangements, similar principles apply in terms of adjusting payments and adjusting time, but there's more avenue in terms of commercial negotiation that's available and not hindered by the consumer protection provisions in legislation.
Yeah, and the domestic contracts are typically, drawn up by the industry in favour of the industry. So master builders contract written for the master builders, and HIA written for the HIA builders. They're generally a little bit more in favour of the builder and less in favour of, the consumer per se. Whereas the commercial contracts, are written to an Australian standard and probably a little bit more even keeled, where the same stick beats up both people.
Yeah, that's right. But they can be manipulated by either party. So if you're a developer looking to protect your interests, you can obviously make changes and protect your interests, as can the builder through the process of negotiation. You're just not constrained by what exists in the residential space in terms of legislation.
Yeah, and what's interesting, and I can speak to myself personally in this one, where I got caught out by this on one of my first projects going way back in the day. A builder can and will actually give you, I guess, a domestic contract, even when legislatively it might not necessarily be legally valid from a I guess, a jurisdictional point of view. So, for example, I did a 6-pack of townhouses, was given a HIA contract, and yet the QBCC does not recognise anything greater than 3 dwellings, I guess, from that domestic perspective. So you can get caught out even though it looks like it's kosher.
Yeah, and it's not uncommon for some commercial builders and commercial developers to use modified versions of those contracts, but they're modified in such a way that they address, shortfalls in terms of insurances and what might need to be there in terms of a commercial contract. Whereas in the domestic contracts, those things don't take front of center because they've got the home warranty provisions kind of sitting behind them.
Yeah.
And which is why in the commercial world, Australian standard contracts take the predominant form. They're usually been amended in some way or another. But even the bespoke contracts that are used by builders and developers across the country are all, for want of a better word, bastardized versions of those contracts.
Yeah. So, okay. So we're going to choose a contract type based on the size of the deal that we're actually doing. Rule of thumb, this will change across, I guess, the different jurisdictions in different states. But from a domestic contract perspective, if it's 3 stories or more or 3 dwellings or more, then chances are it's going to be, I guess, interpreted as a commercial contract, whether it's written on one or not. Would that be fair to say?
Yeah, that's fair to say, Rob. And then you might need to turn your mind to what other contracts are available.
Yep. So if you're doing anything more than 3, folks, then make sure that you're, or at any stage, make sure you're actually, I guess, talking to a construction lawyer when you're having your contracts drawn up. But definitely, you want to be looking at them when you're starting to do larger projects, irrespective. So some of the clauses that we might be putting into these, so special conditions to try and protect ourselves up front. I guess the most common one would be liquidated damages. So how and what is liquidated damages? And I guess what are we legally able to claim? Because I know that every time, I guess the builder tries to negotiate it at not much at all, and we try to negotiate it as high as humanly possible. So what is it? How does it work? And what are we actually legally entitled to do?
Okay, well, liquidated damages are what our best estimate, or the party's best estimate of what are the likely losses to the owner should the building not be completed within the time that's required. And typically, you'll try and have a completion date or what they call a date for practical completion, and you would prefer that date be stated. And often time periods and commencement dates are unhelpful because you might have a onerous definition of a commencement date and it linked to a period, and then it's very hard to calculate the actual completion date. So the preference would be to nominate a completion date by reference to the calendar date. And DLDs are your entitlement to losses that flow from the delay of not completing it on that date. Now, you don't always know what those losses are going to be, but they're likely to. You've got to actually come up with some genuine pre-estimate of what your loss is going to be. And if you expect that you might have to have accommodation costs elsewhere because you have to leave a rental or whatever it is, they're the kinds of factors that come into play. And it's not just leaving it blank doesn't help you necessarily come up with an estimate.
Yeah, so we're talking things like holding costs. So what's the interest rate that you're going to be paying? What's the debt you're going to have accumulated? Land tax rates, insurances, all those sorts of things that are actually going to be impacting you along the way. Now, we're not allowed to profit from it, but we're absolutely able to, so I guess, negotiate where humanly possible. I guess the impact of that loss. But it is a negotiation, folks. You're not automatically entitled. So now, one of the ways that I try to encourage my builders to take a higher liquidated damages number is if I'm going to have a stick, I also want to have a carrot. So I'm going to say, well, if you run late, I'm going to hit you with the stick. But if you run early, you're saving me all those costs. So why shouldn't I reward them for finishing early? So that's kind of how I try to deal with it. To go, well, let's have the same carrot and stick. But if you finish a month early, then you're saving me a month's worth of holding costs. I'm happy to pass that through.
Yeah, bonuses for early completion are relatively common in Australian standard contracts, and perhaps it is a good incentive, but you want to make sure you've got the fallback there for the delay if they're late.
Yeah, absolutely. So now we spoke before about I guess the domestic contract versus the commercial contract, but within either of those, what happens when I guess the cost of the materials might change along the way, and the builder comes and says, hey, this is hurting me, what can I do? Are there things like escalation clauses and that sort of thing that they can build into the contract to so there's an actual mechanism to make that claim, or is it just the builder has to suck it up?
Yeah, in the domestic contract space, some of those things are a bit harder to incorporate. So there's regulation around how the contract price can be adjusted. Therefore, if you've got something like a change in the cost of materials, unless it's a provisional sum or something similar and nominated as such, it's going to be very hard for a builder to argue about the change in the cost, unless it's framed as some kind of variation to the contract where, provided you get agreement on that in terms of what the value is and what the impact is, that's the most sensible way to deal with it in terms of the domestic space. In the commercial space, you're less constrained by the consumer protections, and you can have a clause that says, if my materials increase by X%, then the contract price changes, by whatever. You can have a formula or mechanism in there that could be agreed up front, or you deal with it as a variation or provisional sum or some other mechanism for adjusting the contract price, which in the commercial space is much more flexible.
Yeah, so you mentioned a provisional sum, so a lot of people might not be familiar with that term. So there's, I guess, the provisional sum and PC. I think I'm having a brain fade here.
Prime cost items. So
prime cost items.
Cost items and provisional sums, you nominate what they are.
What's the difference between them? And I'm seeing a hell of a lot more contracts now where those things are being loaded up quite heavily in order to lock in that mechanism to change those.
Yeah. They're just mechanisms in the contract that say, well, this is what we expect the cost of this item to be, and there might be nominated as a prime cost item, for example, and given a value, and then there might be a provision in the contract that says, well, to the extent there's any change to these prime cost items, this is how you calculate the change, and there'll be some kind of description in the contract as to how to do it. And the same with provisional sums. It's usually the difference being a provisional sum is usually directed at not just an item or a component, but an actual service. So there might be a section of the work, say for landfill, for example, and because of the volume of landfill, it's given a provisional sum because it's there or thereabouts. And to the extent that the volume ultimately changes on the site, there'll be a formula to adjust it. So there are mechanisms that are already in place and embedded in domestic and commercial contracts for these values to be adjusted. But, there's also other mechanisms where, you can use as well, and specialist clauses or variation clauses are typically used.
Yeah. And so one of the things that I like to put into my contracts is, I guess, when somebody's making a claim on a payment, I like to say, well, I'm happy to pay the claim, but I want to have copies of the inspection certificates along the way to make sure that, firstly, I know that the subbies have been paid in the first place, because they won't issue the inspection certificates unless everything's been paid off and signed off and that sort of thing. But two, if the builder goes broke, I've actually got those on file, so the next builder can actually take over as a clean handover. How do we put something like that in, and what are the, because I know that there's security of payment system laws that might sit in around what we can and can't do from a mechanism perspective.
Yeah, that all comes down to how you structure your claims for payment in the contract itself, and it varies depending on the type of contract. So in the domestic space, you obviously have frame stage, completion stage, whatever stage, and they're not necessarily specified about exactly what work has to be done to constitute completion of those stages, but it's generally accepted, industry wide, what constitutes those stages. But commercial contracts, well, even in the domestic space, you could stipulate within that stage what is required for completion of that stage. So there's no reason why you can't have, for completion of, frame stage, we require X, Y, and Z as being the requirements for completion of that stage, because you've actually nominated within the stage. Now, it's not typically done that way, but that is what you can do. In the commercial world, you can also have milestone payments or stage payments. And again, you can specify exactly what's required to complete or satisfy those stages or milestones. And like you say, it's a good idea to do that, because it's only once those criteria are met that the milestone is triggered. But it's got to be carefully worded, particularly in the commercial space where security of payment operates. Security of payment doesn't operate in the domestic space, but in the commercial space, it operates to encourage progress payments to be made on completion of work progressively. But if you're very careful about how you word your contracts and your rights to claim for payment, then, and they're very closely linked to completion of milestones based on strict criteria, then you can sidestep the security of payment legislation in what might be rights that are triggered to payment outside of the contract, if that makes sense.
Sneaky stuff. But I guess we're not trying to be sneaky. What we're trying to do is make sure, look, the work that is actually done is actually paid, and where appropriately done should be appropriately paid on time. So
yeah, and certainty is always preferred. So to the extent you do nominate particular tasks as conditions to achievement of a milestone, that provides certainty.
Very good. So, okay, we've done everything to set ourselves up for success now, and we're in a contract. We've signed somebody up. They're doing their thing and building away. How do we actually monitor them along the way, and how do we actually get the early telltale signs that the builder might be going broke? What are some of the things that might be giving us the spidey senses on the back of the neck going, hey, we've got to be careful here?
Yeah, there's some classic signs that suggest the builder might be in trouble. And the first one that's often noticed is less labour on site, and the progress of the work starts to slow. Or there might be rumours between subcontractors about payment not flowing through, or delays to payments being made to subcontractors. Yeah, they're the kinds of messages that'll become increasingly clear as to there might be a problem with the builder.
Yeah, and so I guess for me personally, I guess regular on-site meetings to, I guess, make sure that you're A, inspecting what's actually happening, and B, building relationships with those subbies so that they feel able to have an open candor with you as to how things are actually going. But C, you actually get to see, I guess, that activity slow, I guess, in real time, and you can get to actually start to talk to people and go, what the heck's going on?
Yeah, monthly reporting or some kind of regular reporting is also really useful, not just, and that's across any level of contract, particularly in commercial contracts on bigger projects. You really do need the monthly reporting in terms of actual progress of the work, and it's the site meetings together with that regular reporting that you become familiar with what's actually going on.
Yep. So, I guess we touched on, I guess, how to manage them through is, I guess, regular on-site reporting and having the tradies on side. But there's also opportunities where let's understand what might be slowing things down. So if we're having those regular catch-ups, is it there's a supply chain issue that's happening, in which case maybe we might think of alternative products or alternative solutions. Maybe they can't get a certain certain tap or fixture or fitting? Do we look at alternatives to try and bring that through? So we want to be having those chats all the time in an ongoing basis with our builders to make sure that we're on top of it.
Yeah, being pragmatic about how you might resolve a supply chain issue, or the fact they can't get their hands on a particular component. You might want to change the selection of the particular component or a fixture or finish that is readily available. You might also want to think about design changes. There may be options to actually change the design to facilitate a solution that can be achieved far quicker and far cheaper. And you should be able to keep an open mind about that, because it's simply a matter of recording a variation to the contract itself that would, might avoid a significant delay.
Yeah, absolutely. So all of that is, how do we try and monitor it as we go? We're starting to see the builder get shaky at this point in time, and they're trying to give us some claims to go, hey, can you pay early? That's a really good telltale sign. I just need to put a deposit down for this material. Can you kind of send it through a little early? At that point, when we know that we're shaky, we've got a couple of choices. There's the legal choice, which is, hey, we've got some protective mechanisms in place. And then there's the moral choice, is to say, well, what can we do to actually look after the builder? Because if he actually does go broke, whilst we've got this legal mechanism in place, it's a pain in the ass, and it's going to cost us a whole bunch of pain. It's going to cost us a whole bunch of holding costs and potentially a whole bunch of other things. So, where possible, I always try to manage the human before leaning on the contract. That's at least my take on it. Mate, what do you see in the real world?
Yeah, I see less of the human in my space, because I get calls from people. I get calls from people who want the contract dealt with. But I know what you mean, and I think being pragmatic with the builder is the smart course, because if there is a way, as we said, to come to some alternative solution or help manage them through a period where they might, be short-staffed or whatever it is, it probably will save you costs in the long run, and you don't end up engaging people like me to turn to the contract.
Yeah, the best contract is one that stays in the top drawer and is never needed, in my humble opinion. But but know that it's there and protects you where it can. So okay, at this point, we've got a shady character. They're running short of cash, and we can see their knees are starting to bend a little bit. We've got a few, options, and it's going to change slightly depending upon, is it that residential contract or is it a commercial contract? So let's talk to the residential contract first. So if they've got a residential contract, what are our protective mechanisms that sit in there, assuming that the size of our deal actually fits inside a residential build perspective?
Yeah, so I guess you have to consider what your rights are in terms of time and cost. So the two things that spring to mind are liquidated damages for the delay on the project, and the time in terms of responding to requests for extensions of time. And the two kind of go hand in hand in terms of, if you extend time, you reduce your right to LDs. So those things are there. But when you know that you kind of past the point of no return with a particular builder, you really then have to turn your mind to the termination clause or the breach clause in the contract, and whether you use that termination or breach clause in the instance. So the breach clause, for example, might be for failure to diligently progress the work or failure to reasonably progress the work. That might be the time to pull out the breach clause and issue it. That might get a response. It might be not the one you want, but it might kind of bring it to a head. You also might need to consider that, whether, if there is an administrator or something appointed, whether that triggers a termination right, and whether you exercise that termination right.
Yeah. Now, within, residential contracts, there's the homeowner's warranty insurance that sits there, and a lot of developers believe that they're protected under that. Let's talk to, whether or not we as a developer would be protected, assuming that we are legitimately the right sized deal to fit inside that residential contract.
Yeah, so if you are a contract that's covered by the home warranty scheme, then yes, you will be able to claim for an incomplete work, for example. There is the opportunity to claim through the scheme the cost of having that work done by submitting a claim. Here in Queensland, it's the QBCC. So you submit your claim to the QBCC, and they can appoint a builder from a panel of builders, and they will over time progress the work. The problem with doing that, though, is there is a significant delay because of the sheer number of troublesome projects. There's significant delays with the QBCC of up to 6 months. But they're the types of claims you can submit as the developer, provided you fit into the criteria of the scheme.
Yeah. Now, on the same token, that home warranty insurance does not apply if it's a commercial contract. It does not protect the developer at that point, is my understanding. Is that correct?
Yeah. So if the scheme doesn't apply, and you're not protected by the home warranty insurance scheme itself in whatever state you're in, there are other mechanisms in your commercial contract that you might want to consider. And some of those mechanisms include there's similar breach or show cause notices in commercial contracts that are likely to be used or typically are used. And there's also a step on from those, which is the actual removal of the work from the contractor. So when it's kind of got to the point of no return, you might consider using that removal of work from the hands of the contractor. And the benefit of doing that is that it immediately suspends payment. So at that time, no more payments due, and it allows you time to go and source another contractor. And it also allows you to reconcile the costs of what you would have paid with the original builder versus what you do pay with the new builder, and claim those extra over costs against the original builder on completion of the work. Now, if we know that the builder is likely to be insolvent, that may not be a huge advantage. But what it does do is kind of crystallise the position, suspend any future payments to be made, and gives you the right to claim a formal proof of debt through the liquidator if it goes down that path, but it may not.
Yeah. So we always want to be, whilst we know that these mechanisms are available to us, we always have to actually understand not just the legal rights, but also the implications on us as the developer in a whole bunch of things outside of the contract. So, for example, the financial implications of this, if you are, terminating a builder, it's going to take you time to find another builder. If you have to make a claim through the regulatory authority, that might take quite some time. So that means that you've got holding costs that you need to cash flow. You've got interest that you need to cash flow. In a lot of instances, that might mean that the finish date on the project is almost certainly going to extend. So if you've got some pre-sales on your contracts, then maybe your pre-sales actually start to get to a point where sunset clauses start to get triggered, and so those pre-sales are no longer valid. And I guess on top of that, if you're using a commercial lender or even a normal lender, you might get to the point where you've gone beyond the duration of the term of the finance clause, so you might be into penalty interest rates. So you don't want to be making these decisions to terminate your builder lightly, because it's more than just replacing the builder. It's more than just finishing the project. It's what happens with all the bits in between.
Yeah, I guess through the process of decision making and making inquiries about who else might be available to take on the contract or complete the work, through that process of finding out those things, you can make those decisions along the way. But the good thing to know is that the mechanism's there and you can trigger it straight away. Of course, you might have to issue a show cause notice or something first, but if you want to trigger that mechanism, it's there and you can trigger it immediately, and that starts the ball rolling in terms of how you might affect the changeover, so you're not wasting time negotiating, because that is the trap, is that you try and help the builder through and be really pragmatic, but it comes a point where you've wasted 2 or 3 months going down that path, whereas had you made the decision 3 months earlier just to cut, provided someone else is available to step in, Had you made that decision earlier, you've saved all those overheads for that period.
Yeah, absolutely. So at this point, we could weighed up our options, that sort of thing. We've decided to pull the trigger. What are our actual termination rights? What allows us the ability to say you're dead to us? Get out of Dodge.
Well, a lot of the domestic contracts have a provision in there for insolvency. So if you're dealing with a company, a building company, the Corporations Act determines when a company's insolvent and what happens with the appointment of an administrator or a liquidator. And you only talk liquidators and administrators when you're in that corporate world and dealing with a corporate builder. But as soon as those things happen, that triggers your right to terminate in most kind of domestic spaces and in commercial contracts as well. In terms of the bankruptcy of an individual builder, that's usually also written in the domestic building contract. So as soon as an individual or sole trader becomes bankrupt, that triggers your right to terminate. And really, from the point that they're bankrupt, there's no point at that point continuing the relationship. And in many cases, the regulatory authority soon after cancels their license, and the contracts are void at that point anyway. So so that triggers your rights, and it's really just checking that you do have a contractual right to do it and actually executing the notice of termination in accordance with the contract. Quite often in commercial contracts, even if there's not a clear clause, you'll have common law rights of termination, but 99% of the time there will be a clear clause. And if you do have to rely on common law rights of termination, it's just reasonable written notice of the breach, which is the insolvency.
Yeah. Now you did say this in what you said, but I'm going to try and reframe it just so that some people will catch it a little bit better. The difference between bankruptcy and insolvency. So bankruptcy is for an individual. So if you've got a builder who has a builder's license in their own name, I guess then that's going to be where that happens. Whereas insolvency is to a corporation, so I guess an entity that might be actually having the license. So part of your decision-making process would, I guess, in choosing your builder would be, well, the size and professionalism of the builder. Has the builder's license in their own name versus is it in an entity? Because you've got completely different rights in order to claim against that builder in the first place.
Yeah, and chances are with a corporate entity, you can have greater access to financial information and financial material. But the world of administrators and liquidators being appointed to a company is only in the corporate world, the Corporations Act world, and that's all regulated through, as I said, the Corporations Act, whereas the bankruptcy is the insolvency, the trustee in bankruptcy that winds up an individual, or that someone petitions for an individual to be made bankrupt. Once that happens, there's not a lot of avenue for communication because you're dealing with the bankrupt person, or the trustee in bankruptcy potentially is a third party, but they're less likely to be available for advice and communication as might be an administrator or a liquidator in a corporate scenario. Those people are more likely to give you regular updates in terms of what's happening with the liquidation. You get creditors' reports, you get notice of meetings, and they usually send out information about how to lodge a formal proof of debt if it gets to that point.
Yep. So two other bits of terminology that you mentioned there. So I guess a liquidator versus an administrator. So what's the difference there? And when somebody gets into those two bets, which one do they panic the most about?
Yeah, I'll panic with both, but there's slightly less panic with the administrator being appointed, because in theory an administrator could come in and try and resurrect the company and try and actually get better returns
trade out of it.
Yeah, effectively trade out of it for the benefit of creditors. And there are actually safe harbour provisions and what they call ipso facto clauses in the Corporations Act that allow the company time, so that in some instances you can't just terminate. And I think one of the master builders domestic contracts makes reference to that, at least here in Queensland, to the exceptions in the Corporations Act around the right of termination. So you'd have to get legal advice about your right of termination if there was an administrator appointed and they were holding out that they were actually trying to trade out, and they might be protected by those provisions in the Corporations Act.
Yeah. Now, mate, my Latin is a little bit rusty. So ipso facto and safe harbour, which is a little bit more in plain English. What do those terms mean?
Well, the safe harbour provisions are all about where I mentioned giving the administrator time to actually try and trade out. So it gives him an extension of time by which he has to do certain things in terms of regulating the company or calling in a liquidator if it gets to that point. So it allows him further time. And the ipso facto, meaning the clauses that speak for themselves in terms of how you might terminate, they're qualified by these new provisions in the Corporations Act that says you can't necessarily rely on the words where these exceptions occur. So referring back to the safe harbour provisions where the company's actually trying to trade out, that's an exception to the right of termination. So it just gets a little bit tricky in the instance that the administrator is actually adopting that course. But in my experience, it's very rare that occurs and that an administrator is actually genuinely trying to trade out. And the administrator usually will, within the statutory time limit, thereafter appoint a liquidator, or a liquidator will be appointed soon after.
Yeah. So we, I guess, have identified that we want to terminate someone. Is this just, a little bit like The Apprentice? So do we just go, you're fired, or is there an actual formal process where we actually have to notify that termination, and how do we get the ball rolling in that regard?
Yeah, in terms of the termination under the contract, there'll be a clause that directly addresses how you do that, and it's usually by written notice stating why, or it may be simple as written notice referring to the clause because the clause states why, and it's because of either the appointment of the administrator or the liquidation of the company.
Yeah. Now, you touched on this earlier in the piece, but I'll come back to it. I guess once we've issued the notice of termination, I guess ceasing payments, like that seems like a pretty obvious thing, but talk to us about that. Why do you want to cease payments? This guy's broke. Surely we want to try and help him out.
Yeah, well, in the context of the process, and the process might be that you issue a breach notice first before you actually issue that final termination notice. Quite often the builder, as soon as you start, they recognise you're starting to position in terms of breach, they might ask for some further payments, or they may even ask for advance payments, as you mentioned. I know in the Porter Davis case that wasn't uncommon, but thankfully some of those payments were actually made to third-party trust accounts, which offered a level of protection for those people that were asked to make those payments in those trust accounts. But others weren't so lucky in terms of where those payments were directed. But yeah, it's all about knowing what comes up at that time and before you actually issue the final termination notice. Yep.
So at this point, we've terminated him. We've asked them to leave site, and if need be, we've I guess given them a gentle tap on the shoulder to go, off you go, mate. So what do we do at this point? The site is, I guess, still a construction zone. What do we need to do to actually, I guess, document where the process is actually at, so that the next person actually can take it over and we know exactly what the validity of our claim is?
Yeah, securing the site's probably the most important thing. Making sure that that you've got access to and secure the site, or at least have some security on the site. Making sure that people don't access the site and randomly take things off it. And getting a status report. So knowing exactly where the works are at in terms of progress and getting a detailed report about that, because that will be useful moving forward, no matter which avenue you go down in terms of renegotiating a contract with a new builder or making claims in respect of payments that should never have been made, or payments that have been made in excess of the value of the work that's completed.
Very good. Okay, so we've secured the site. We know exactly what we've got in place. We know roughly what our claim is at this point in time. We've now got an administrator or a liquidator that's now, I guess, taking over the building company. So what do we do in order to, I guess, lodge our claim with the administrator? How do we actually go through that process?
Yeah, as I mentioned previously, they usually provide you with information about what's happening in terms of the progress of the liquidation or the administration. You'll get notices, but it's always useful to make early contact with those people who are typically accountants at larger accounting firms, and actually put your details forward in terms of being supplied with all the relevant information, just so you don't miss out on anything, and you can see the progress and lodge a formal proof of debt if you need to.
Yep. Now we've got a claim that's sitting there. The administrator, it's out of our hands. They're going to try and do what they can to try and navigate that through. In the meantime, we've still got to find another builder. So that's really going to come down to, is it a residential contract or a commercial contract to find that other builder? What's the process under a residential contract perspective to find that other builder? Do we just go and find, Bob the builder down the road and go, hey, mate, can you start? Or is there a process that we need to go to make that happen?
Well, if you've terminated the earlier contract, I guess you're back where you started in terms of due diligence and the rest, and trying to find a builder that you want to engage to move it forward. In the commercial world, there's probably a few more complications that come into play. You might have subcontractors claiming claims up the chain and bypassing the builder. You might have PPSA claims coming from subcontractors and suppliers down the chain in the commercial world, up bypass the builder up to the developer. There's mechanisms in specific legislation here in Queensland, and I know it's a bit unique here in Queensland, but subcontractors can ask developers to retain money that hasn't been unpaid or hasn't been paid by the insolvent builder. So you might be working with the liquidator to some extent on managing those claims. And you might also be facing PPSA claims from subcontractors and suppliers who say they have an entitlement to proceeds for their gear on the site or whatever. So some of those issues might come into play as well in the commercial space.
So you mentioned PPSA a couple of times there. So it's an acronym. What is PPSA, and I guess what do we need to be aware of?
Personal Property Securities Act, that's a Commonwealth legislation that applies across the country in terms of registration of plant, equipment, vehicles, and materials to some extent, and about how you register those things on site, on delivery of certain products. The people that have the interest in those goods can register their interest under what they call a security agreement, which is the agreement by which credit is provided, in effect, by providing the product before payment. And you can secure your interest in that item if you're the owner or supplier of the item on the PPSA registry. So it's effectively a registry of interests, and a particular party, depending on how they register their interests, might claim money bypassing the insolvent builder and up to the developer in respect of what they say is their interest. But, it's all subject to proof of their interest and their registration of that interest on the Personal Property Securities Register.
Yep, very good. So back to, I guess, trying to assign, I guess, a builder in the first place. If you are, I guess, using a residential contract, and you're trying to get the regulatory authority to actually appoint a new builder, what's the process, the timeline? How long does that typically take in order to do that?
Yeah, so in terms of what might happen here in Queensland, you would put your application in for incomplete or defective work. So assuming the work hasn't been completed, you would put your claim in for incomplete work. It would be processed, and it might be up to 6 months before they actually appoint a new builder to undertake the work. But the benefit is you know that you're only ever paying the cost that you're always going to pay under your contract. You're not paying any more uplift costs because it's all protected by the statutory scheme. But what you are facing are those extensive delays and the overheads that could be a real problem.
Yeah, and those extra costs with the overheads, are they claimable against that homeowner's warranty insurance?
There's certain elements of costs that are claimable, things like alternative accommodation, storage, things like that are claimable, but to fixed limits, I think it's only $5,000 or something like that in terms of what you can actually claim.
Nothing of substance.
Yeah, not significant. And the claim itself is capped out at a $200,000 limit unless you've paid additional premiums for further. Yeah, so there's caps on that as well, but hopefully, you're not exceeding those limits.
Yeah. So in the commercial world, I guess if we've got a commercial contract, appointing a new builder there, you touched on it before, do your due diligence, find the new guy. But is it a matter of we can just assign anyone we like at that point? Because, you can. We're outside the scheme.
Yeah, you're outside the scheme. You're not going to have any insurance process to fall back on. You might have, compulsory insurances under the original builder's contract, and some of those may refer to you as an interest holder. But at the end of the day, you haven't got any real regulatory body to fall back on. So it's really up to you to decide how you're going to move forward. And once you've terminated that contract with the builder, you can, or taken the work out of their hands, depending on which avenue you go down, you can engage the new builder to complete the work.
So what about some gotchas? And, we didn't cover this prior, but hopefully I can put you on notice. What happens if we've terminated a builder and they in turn try to put a claim on us? Well, are there any gotchas that we need to be worried about from there?
Yeah, look, it's not uncommon for in those initial stages when you breach a builder that they try and say that you're repudiating your contract. That's a pretty standard kind of response from the builder. But it all comes down to evidence-based stuff. So if you say they're in breach because they've delayed the work, it's really about what evidence you've got to demonstrate that breach and demonstrate that ability to show that they have delayed the work. For them to say you might have repudiated the contract, well, on what basis? Again, it becomes an evidentiary issue.
Yeah, and from a cash flow perspective, things have slowed down for the builder. They might still be progressing, but at a snail's pace. So how do you demonstrate that how much of a delay is a delay?
Depending on the wording of the contract, it usually says reasonably progress. So say, and this is the more common scenario, that 75% of the work is done and there's only somewhere around 20 or 25% remaining. And what might you typically be expected to be finished in 2 or 3 months has extended out to 8, 9, 12, 18 months. And for some people, particularly in the domestic space, 2 years. Then that's not uncommon to hear that. So it's really not difficult evidentiary to prove that given the status of the work 2 years ago, they should have completed.
Yeah, absolutely. So in wrapping up, mate, what are some best practices, recommendations that you would suggest to people, I guess, to A, try and avoid it, and B, manage it through?
Yeah, those things we mentioned, the due diligence up front, making sure you're satisfied with who you're going to go with and you've done your checks, getting your contract reviewed by someone like me to make sure that you understand what nuances you can place on the contractual clauses, particularly if you get a contract from the builder, and how you might have that contract reviewed and amended to balance the risk profile a bit more evenly. And from there, it's all about the management So the management and administration of the contract itself, which, as you mentioned, going to meetings, making sure you got monthly reporting, you got some form of, particularly for commercial projects, that you've got some form of program of work that you can have updated or revised and managed. All of those things. And then most of all, having a pragmatic approach, as we said. If there's a way to solve a problem and it saves time and money, keep your mind open.
Yep, mate. All of those, that fantastic advice. I would probably add one more to there. I guess you did touch on, engage with someone like yourself, but also make sure that you've got the right kind of contract for the right kind of build. So you're not trying to, squeeze a commercial contract. Using a residential. You might be doing 4 or 5 or a 6-pack or something like that, and someone's putting it on a master builders or a HIA contract. It's probably not appropriate, and so what looks like it is kosher isn't necessarily kosher.
Yeah, and just coming back to getting someone to have a quick look at it and make sure that it fits your project, and particularly around the payment mechanisms and the payment staged payments and how that works is critical.
Yep, very good, mate. It's been an absolute pleasure. We've got plenty out of that, so thank you very much for the share. For those of you who are watching, not only do we do these Sunday sessions, but we also run regular networking events all the way around the country. So we run them in Brisbane, Sydney, Melbourne, and Adelaide. If you are keen to come to those events, it's only $25 to come to those, or we have an annual membership for $250. If you go to that developernetwork.com.au/events page, then you can come to one of our things. And Julian has kindly presented to us there before in Brisbane, and no doubt will present there again at some point in the near future. So, mate, it's been an absolute pleasure. Thank you very much for your candor on all of this. Hoping that we're coming to the other side of this. I'm seeing a lot of this stabilizing now. All the challenges we've had in the past are now a lot more predictable. A lot of those cost escalations kind of happened in very fast progression, but now with new contracts are a little bit more predictable, but we still have to be ever vigilant. So make sure that you engage with people like Julian along the way.
Thanks for having me, Rob. It's been great to join you.
Mate, it has been an absolute pleasure. Until then, folks, we'll see you all next time. Bye.
Bye-bye.